My name is Matt Lowy. It's nice to meet all of you. I work at the Missoula County Attorney's Office. I want to give you a little bit of background about me, how I wound up here, so you can appreciate my perspective and everything. I graduated from Montana State University in 2001 with an English literature degree. I was shocked I couldn't find a job. It didn't matter that I had highest honors and I'd done well in school, so I went to law school, naturally. But I knew when I went to law school that I was never going to practice law because lawyers were, insert expletive here. I mean, I just didn't believe that I wanted to be an attorney. And so for my first 2 years, I had a great time chasing my future wife and ensuring that she'd accept my ring when I offered it. And my third year of law school, I interned at the Missoula County Attorney's Office, and I was a criminal prosecutor. And I fell in love with practicing law. I had no idea it was going to happen to me. It was wonderful. And I graduated law school. I immediately started prosecuting in Gallatin County. I did criminal law for 2.5 years in Bozeman, Montana. Marty Lambert was the Republican county attorney down there. And they do justice a little bit different than we do up here in Missoula County. And I wound up back in Missoula County. I've been working under Fred Van Valkenburg since November 5th, 2007. And when I took the position here, I was half-time civil and half-time criminal. And I took a dual caseload, and for an additional year, I continued practicing criminal law. And through a shift internally in the office, I wound up as a solely civil prosecutor. And so all I do is represent Child and Family Services, and that's what I've done since 2007. And in addition, I do some other civil work on the side, but the increased caseload recently in Missoula County has led to me doing even less other work and focusing almost exclusively on representing Child and Family Services. In 2012, the National Association and the Council of Children started offering a special certification for law licenses, a certification as a child welfare law expert. And I'm one of 3 attorneys in the state of Montana who has that certification on his law license. And one person is in Billings, and the other person is my wife, who used to work for the Attorney General's office. And she usually does this presentation, but she's in the legislature in Helena right now, representing Missoula County. So she's not here. Unfortunately for all of you, she's smarter than me, and she's had experience doing this, so you'll bear with me as we start through this first round. So my job is a lawyer. My job is to be an advocate. I represent a client. My client is Child and Family Services. It's a state agency. I'm not here today to be an advocate for my client. I'm here today to tell you what I think the law says, and I'll give you citations to the authority because what I'm doing is pretty much quoting chapter and verse and giving you a couple of cases that might interpret it. I am still a prosecutor. I was a criminal prosecutor for the first 2 years or so that I did this job, and I think that was the wrong approach, and I've really evolved as an individual and how I come at these cases as a direct consequence. Really, one of the richnesses of practicing law for me is getting to know my client's profession inside and out. I have no social work background, I have no social work training, and I routinely state that I am not a social worker because I am not. But I have a pretty good understanding of what my client is obligated to do and how to practice social work. And it allows me to be an effective cross-examiner of witnesses and to bring out the important stuff on direct for other witnesses. And like I said, part of the richness of practicing law is learning your client's profession inside and out. So I really take a lot of pleasure out of getting to learn more about practicing social work. And it makes me less of a prosecutor. But I hope that all of you will be as critical of me as you were of the other presenters and look at the presentation I give you through the same critical lens so that you're not taking everything I say at face value, but instead recognizing that this is coming from somebody who represents Child and Family Services. And there's no 2 ways around it. I represent the government. And we are the government who is intruding into the family life. And the whole purpose of the Constitution of the United States of Montana is to restrict the government. So that's what we're coming to you with in this presentation. Now, I'm supposed to tell you first about the law. So let me tell you a little bit overarching about the law. I'm going to give you a little piece of history, and then we'll get into the nitty-gritty. And I'll probably race through the history part faster than the legal technicalities and specifics. State of Montana. We are governed by the federal government. They're at the top, and the top is the United States Supreme Court. You don't have to look any further than Steve Bullock's challenge to the campaign finance law. Yes, thank you. Whew, Citizens United challenge. It's a good thing you guys are paying attention. So that was overturned by the United States Supreme Court. And who were they reviewing? They were reviewing our state Supreme Court. State of Montana does not have an intermediate court of appeals. So our state Supreme Court, Chief Justice McGrath was the one who wrote that opinion, and Justice Nelson retired. He wrote the dissent. They were both reviewing the ruling of Judge Sherlock at the district court level. And the district court is where all of you are going to appear, in the district court level. Now, there's also special masters who you will see in Missoula County frequently, and we are very blessed to have them. We are incredibly fortunate. There are also justice courts which you may have interaction with, because a lot of the people that we're dealing with are caught up in the criminal justice system in one way or another. And misdemeanor crimes, the original court of jurisdiction, is the justice court. That's where misdemeanors are heard. So DUI 1, 2, and 3, and partner family member assaults 1 and 2 are going to be heard in the justice court, or they can be heard in the municipal court if it occurred within the city. And so you may have some interactions with the municipal court too. Incidentally, I told you about Mike Halligan, who was a legislator, and he became the first director of the Child Protection Unit underneath the Attorney General's office. And one of his successors was Kathleen Jenks, who is now the sitting judge in the municipal court here in Missoula. So we all know each other. Make no mistake about it.
Justice Court, who are the judges, Orsic and...
Judge Odlin, and Judge Odlin's term ends in 20 months. And then we have two special, we have two special masters. We call them standing masters. Standing master is Leslie Halligan. She used to be my colleague at the Missoula County Attorney's Office. She used to represent Child and Family Services in these cases, and she has a very deep understanding of them. The other person is Brenda Desmond, and Brenda Desmond has an equally deep knowledge of youth in need of care cases, and they both facilitate intervention conferences and meetings that the judges never hear about. And they basically try to help us reach resolution in both law and social work in these cases outside the courtroom, behind closed doors, and outside the purview of the judge. And they keep it very separate from the judge.
Is that like a mediation or settlement conference?
It is similar to a mediation or settlement conference, yes. And it's awful difficult because it's hard to say you can beat your child on Tuesday but not on Wednesday and Thursday. It's just kind of how much can you negotiate. Right. So on some level you have to consider what it is when you're going to that conference and what you're settling. And effectively what you're settling is, what is the basis for state intervention and what does treatment look like? Or is this something that we simply cannot resolve without a contested court hearing? And you can also resolve things like placement. What is in the child's best interest for placement? And the standing masters do an excellent job of facilitating those conversations and keeping the peace.
Do CASAs get involved in those?
Yeah. Gosh, we hope so. We want you at every single hearing if we can help it. We want you at every single meeting. But we also recognize that you're unpaid volunteers. And you also have to be appointed to the case. So it's very difficult sometimes for that first intervention conference for a CASA to have already been appointed. And if you have been appointed, then your only information sometimes is you haven't met the child and you haven't done your own independent investigation. So what you're stuck with is the one document in the court file, which is what the state of Montana has filed. And the judge has said, based on these allegations, the court finds that there's enough to go forward with a case. So yes, please come to all the intervention conferences. Just recognize that you may be coming after the second or third hearing, and we'll try to get you in sooner if possible. All right, history of child protection law, briefly.
Yeah.
Do you want to share with the rest of the class?
No.
Oh, geez. Okay, child protection. Right, we talked about, I heard all of you talking about this earlier. In 200 years or 50 years, we'll be talking about how could you lobotomize those children. This is a complex and rapidly developing area of law. It's evolving, it's not perfect. In fact, it's incredibly young. This area of law is only 30 years old. I think the first case that I'm aware of was 1984. Well, I'll go through some of the other cases, but the first United States Supreme Court case that I have good familiarity with, it was in 1984 when the United States Supreme Court said that a preponderance of the evidence, that is just enough to tip the scales, is too low a burden of proof to allow termination of parental rights. And in this case in New York, that was reversed, and that you have to have an established legal standard for termination of parental rights as a floor has to be clear and convincing evidence. And that case also found that a parenting right is a fundamental liberty interest protected by the United States Constitution. So,
say that again. So the initial court found just a preponderance, and that was changed.
That's correct. Once upon a time in the state of New York,
Higher standard.
once upon a time it was just preponderance of the evidence, and now it's clear and convincing evidence is the absolute minimum standard.
And the highest standard, just for you know, lawyers, is in criminal cases. Right? You can
keep going. You're doing great.
It's like it's beyond a reasonable doubt. So the highest standard is beyond a reasonable doubt. The middle standard is clear and convincing, and a preponderance is just
not even that.
Yeah.
Yeah.
Little scale tip.
Sure,
right?
And a proof beyond a reasonable doubt is also the standard of proof that's applied for termination of parental rights when the Indian Child Welfare Act applies, and you're talking about terminating parental rights of a Native American child from their family.
Oh.
So, and I'll go into that a little bit more as we keep going, but it's fun to touch on it more than once throughout this presentation so that hopefully the repetition will sink in a little bit, or I'll put you completely to sleep and I'll say that I've cured insomnia. We'll find out. So, child rights in the 1800s was virtually zero. So we're talking Pennsylvania court said children have no constitutional rights because the court and the state act in the parent's role. In 1853, there was a Children's Aid Society to save homeless, ragged, hungry children prowling the streets of New York. So they sent them to the Midwest. And this is an orphan train. This is a picture of children who were literally orphans and shipped out to religious families in the Midwest. 1874, there were laws to protect livestock, but we didn't have them protect children until the Mary Ellen case, when child abuse led to the creation of the New York Society for the Prevention of Cruelty to Children. So that's a society, but not a legal finding. So this is just kind of the origins of where it gets started. So the U.S. Supreme Court decided states had authority to intervene in family relationships. In Reynolds versus U.S. in 1878, and Davis versus Beeson, the government had the right to regulate polygamy. You can exercise your religion, but you have to comply with criminal law. So the state does have some authority, and it would allow for some governmental intrusion into the sanctity of the home. So the United States Constitution is in place to restrict the government. This chipped away at those restrictions and allowed the government to go into the home under limited circumstances. So then we started getting into some child labor laws. In the 1800s, children made up half of family income. I don't know how many of you have kids, but boy, if my kids were out working, yeah. So 20% of children between the ages of 10 and 15 were employed. They weren't getting an education. They were out working. Late 1800s, early 1900s, children's lost economic value as machinery advanced. And that may be true, but I know my grandfather, when he was growing up as a slum kid in the Bronx in New York, he rode on the back of the family laundry truck. And his job was to run out and to deliver the laundry off the truck. And so he would go to school so he could sleep. And after he was done delivering the laundry, he would do his homework. And that, you know, he was one of these people that child labor laws sought to protect. So we get into the 1900s. So education finally gets some promotion. Child Fair Labor Standards Act in '38, and the government regulated treatment of children. Parents cannot violate labor laws by having children sell religious literature. So, you know, you try to use the the Constitution to make your own inroads in chipping back at when the government can intrude to your home. Well, the Constitution says I have the freedom of religion. And so you use the Constitution to combat the Constitution. Did I say that correctly? Did everyone get that? I see a lot of heads nodding. I'm not always most articulate. 62, child abuse was discovered. First time, 62. First paper published. Battered child syndrome, where injury sustained by a child as a result of physical abuse, and it was usually inflicted by an adult caregiver, because broken bones do not just happen to children. I mean, you think about what infant children do. They pee, they poo, they sleep, and they cry. But their bones are actually incredibly soft, so they can fall or be dropped without breaking bones. And this was defined by Dr. Henry Kemp. There's not just a random picture of a doctor down there. There's actually a name to go with him. And doctors can actually make some determinations based on an X-ray about whether or not a broken bone is the result of child abuse. There's actually something called a metaphyseal fracture, or a bucket handle. And in that case, it usually happens on the ball and socket joint. And it's either, the ball and socket joint either comes apart because of pulling, or it comes apart because of breaking. But when it happens in both ways, then it's known that it's child abuse because it can't occur from a fall. So if it happens from pulling and breaking simultaneously, then it can be definitively identified as being caused by a human being, and therefore it is defined as child abuse. And so there is a lot of medicine that actually helps to support that abuse does occur, and there's just as much medicine to support that the abuse did not occur. And so it's very important when you're dealing with those medical cases that you make sure to look at both sides of the literature. So, 1967, children started making their own incremental gains in rights. Constitutional rights when children are charged with a crime. A 15-year-old boy was arrested without parental knowledge, convicted of making a lewd phone call to a neighbor, and he got a greater sentence than an adult would have received. And no witnesses testified. There was no right of confrontation of those who were his accusers. And there was no court record made, so they were able to review nothing on appeal. And so you have to have a record so that the reviewing court can say, all right, I understand why the court took the action it did. That didn't exist. So fortunately, we got a reversal there. The Montana Constitution, we had our Con Convention in 1972, and we, plain and simply, have a liberal constitution. There is no two ways around it. And this is the best state in the Union to be a criminal. We have an, oh yeah, absolutely. You have an absolute right of privacy. We don't have that in the United States Constitution. That's just in the penumbra of the Bill of Rights. The penumbra is the circle that you see around the moon when you look at it at night. And the penumbra of the first 10 amendments to the United States Constitution creates your right to privacy. But in the state of Montana, it is explicit. And because it is explicit, our rights of privacy are greatly heightened. It's fantastic. Because that's why we live here. We want those restrictions on the government. That's why we're here. We get our privacy, and we want that. And it's more liberal. And it makes it more difficult to prosecute criminals, such as life for criminal prosecutors. Also, gave children the same rights as adults. That is revolutionary. Because children have their constitutional rights set forth in our Constitution, and our policy and procedure in all youth needed care cases allow children to assert their rights to things like a clean and healthful environment, which is a constitutional right. So that child should not have to live in a house without a flush toilet. That child should not have to live in a house that is actually a drug den. And just because the child isn't being directly exposed to it doesn't mean that they're not getting the effects. They get the right to a clean and healthful environment. So here's some other examples that of children's rights, such as an age for consensual sex for children. In 1870, there was a push to raise the age, increasing protection. In 1870, most states allowed age of consent but 10 and 12 years old. Delaware had 7 years old. Once upon a time, Montana was 10. In 1920, most states bumped it up to 16 years old, and then Montana made it 18 years old. In 2007, most states make the age of consent between 16 and 18 years of age, and Montana now has it at 16. Just like the science is evolving, so are the laws. So in '74, the federal government funded some child welfare programs. So in 1978, the federal government passed the Indian Child Welfare Act. So this creates different laws to try to keep Native American families together. Now, I'll also tell you that as part of that law, there was funding made available for the tribes to have an agent who was in charge of monitoring Indian Child Welfare Act and cases that were involved in state courts. And that funding was something in the order of $14,000 or $18,000. I don't remember the exact number anymore. See, if it's not in front of me, I can't remember it. And that funding remains unchanged in 2013. So if you would be willing to work for less than $20,000 a year, you could be a full-time ICWA agent for a state. But otherwise, those are all part-time positions, and those are widely underfunded. And so when you're dealing with Indian Child Welfare Act cases and you're coordinating with those agents, you want to do two things. You want to get in touch with them and find out what their hours are and when they work so that you can coordinate your contacts with them during their working hours. You'll have a better chance of getting hold of them. And the other thing you want to do is you want to sit down with somebody and get a brief primer on the Indian Child Welfare Act, because we could spend about 7 or 8 hours going through it. Yes, Dennis?
We have a training, 3-hour training on ICWA.
Oh, you do?
Yep. Perfect.
Great. So yeah, I'm going to glaze over it, and I'm going to focus on non-native kids for most of this, and I'll try to highlight some of the differences. In the 1980s, there was a series of foster care drift cases. Permanency was never emphasized. So the foster care drift created all these children that were in foster care with the idea that they would be reunified with their parents when their parents got better. And the system would do a terrible job of keeping track of these children. And as a consequence, when their parents never got better, they would simply remain in foster care for all eternity and age out of the system. And they wouldn't receive the services that they needed. They wouldn't get the counseling that they needed. And this was what is termed drift, foster care drift. It's not like that in Montana. Adoption Assistance and Child Welfare Act of 1980 is the first time that they started focusing on permanency for children. And it required tracking and reporting, mandatory reporting, some of the laws for licensing. And the law by itself wasn't enough, and there were still lots of children lingering in the system. But at least it was a step in the right direction.
Excuse me, that's
please.
law.
This is, yes. Kids were growing up in foster care. They went through foster care drift. They lingered in state care. There was no permanency. I highly, highly, highly recommend reading Hope's Boy. It's a memoir by Andrew Bridge. And Hope is his mother. He tells the story of how he helped her commit a breaking and entering crime in Los Angeles, about her psychological instability, and about how he wound up in foster care and what he did in the foster care system. And he wound up going to, I want to say it was Wesleyan back east, because he finally realized that the only way he was going to get out of his situation was through education. And when he was a junior or senior, he really buckled down and focused on schoolwork so much. And after going through Wesleyan, he then went to Harvard Law. And after Harvard Law, he then went through and sued various states for their child welfare law system. And he was instrumental in creating the ASFA, which is the American Adoption and Safe Families Act, which is the next one you'll see here. He did some incredible work as an advocate for kids so that they would not have to go through what he went through. So the Adoption and Safe Families Act of 1997. Policies to shift focus from the parents' rights, it went to the needs of the kids. It promotes adoption, permanent homes, encourage concurrent planning while reasonable efforts are done. So I want to talk about that concurrent piece of it. Judge Harkin was Karen Townsend's predecessor on the bench, and he once told me in a case that the state has the right to do concurrent planning. So on the one hand over here, they are telling parents, you're going to do everything on this treatment plan to be reunified with your kid. And on the other hand, over here, the state is simultaneously planning for where your child will wind up and be adopted and where their permanent placement is going to be. Now, I hadn't thought of it in those terms about the two-faced appearance of the state. I'm with the government and I'm here to help you. And at the same time, the government is saying, we are actually not helping you, we're planning for the permanency of your child. And I hadn't thought of it in that concept, but that is precisely what concurrent planning is. And it's the right thing to do for children. It's not good for parents who have their kids in care. It's actually detrimental to them and can be very harmful. But it is the right thing to do for children, because what you don't want is a child going through 15 months or 2 years or 3 years of reunification efforts with their parents, and then their parents are unsuccessful and their rights are terminated, and the child has to wait another 2, 3, 4 years before they're in adoptive placement and they can have the permanency that these cases are set up to give them. And it must be incredibly trying as a parent to be in one of these cases and to recognize that your child is not just with an adoptive parent, not just with a foster family, but a family that could become your child's forever family. And the expectation that on some level you're going to have to work with that foster parent to try to learn your child's needs. A child who you had taken away from you by none other than the government. I really think that it's got to be incredibly difficult on the parents, and it's one of the things that I, as a lawyer, when I'm in the when we're trying to hash out treatment plans and what treatment should look like, I want to see parents in counseling. I want them to have an outlet so that they can complain to somebody, and so that they can air this. Just because I want that doesn't make it right, but that's my perspective of these cases, and I would highlight the last part for you here. There's a mandatory time limit. If these children who have been removed from their parents remain in foster care, and foster care is defined as substitute state care. If they are in substitute state care for 15 of the last 22 months, the state of Montana has a legal obligation to petition the court to terminate parental rights.
You must.
You must. So now let me put those, yes, please.
But the judge doesn't have to grant that.
Exactly. That's absolutely accurate. The judge has no obligation ever to grant any termination petition. It is entirely within the judge's discretion.
Can you clarify the time class? Because,
Yep.
what if they're in the parent's home, taken out, back in? Is it cumulative?
So what it contemplates, what the law says is 15 of the last 22 months. Okay, so you're in substitute care for 15 of the last 22 months. So I had a case where the child was with their biological mother within 3 weeks of separation. And they were together for 9 months. And the state dismissed, and within a week the mother relapsed, and the state said, we didn't do our job correctly. This parent never should have relapsed. And so they refiled. Child was outside the home for a week. The mother said, I messed up, I'm fixed, thank you very much for getting me about the relapse. And the department reunified the mother and the child, and they were together for over 6 months. And so we had over a year and 3 months of continuous parent-child relationship until the mother didn't just relapse, she went on a 6-month bender. And during those 6 months, everyone tried everything they could to get her into treatment, and she could not. And in those 6 months, they were separated. And the department thought that the right thing to do at the end of those 6 months was a petition for termination of parental rights. So just because it wasn't mandatory, the department still saw that they had been working with this parent for 2 years, and in those 2 years, there had not been changes of the reason why the department got involved in the first place. And so the department thought that that was in the child's best interest.
So you could petition sooner, but you must at 15.
Correct. 15 of 22 months, yes. Well, if the child's out of care. So I guess the other thing I would add is, my understanding of the studies is that they showed that children who reunify with their parents within 4 months of separation have the highest rate of successful reunification and dismissal. And so when you have children who are out of their parents' care for 12 some odd months, and you go to your first permanency plan hearing, which happens every 12 months, and should be part of this slide, every 12 months you have to have a permanency plan hearing. You should be looking at the prospect of whether or not the child's going to be going home or whether or not you should be looking at a termination. Because that child at 12 months should be, you should know whether or not the parent is making changes and how close they are to reunification. I actually have a case right now where the child is 13 months old. The child spent the first month in the hospital, and for the next 12 months, the next 11 months, the biological parent did nothing. And for the last month, the parent has done something. And the parent's position is, it hasn't been 15 months. Therefore, you shouldn't terminate petition the court to terminate my parental rights. And the department's position is, you are correct, you are doing things in the last 4 weeks. And this child is 13 months old, and it is the child's entire lifetime. And so those 12 months that you're talking about are a lifetime to this child, and this child is not going to wait for you anymore.
But has the child been out of the home that whole time?
Correct. And as I was
on 15 months.
coming up on 15 months, but you're not there yet. Give her another 3 months. And as I was saying, the concurrent planning is detrimental to parents on some level, because what's happened to this infant child is this infant child has an incredibly strong parent-child bond with the foster parent. And that's what's accrued in those 12 months that the biological parent has done nothing. Completely apathetic to reunification. And while the last 12, the last month, the last 4 weeks have been very positive and steps in the right direction, to that child, the biological mother is a stranger. What's in the child's best interest? So my job as the department's attorney is to go to court and say, well, it's obvious here, Your Honor, what the child's best interest is. And there are some very valid points for a parent's lawyer to make that all children, because studies do show that children do better when they are raised by their biological parents. And for a lawyer to stand up before you and say termination of parental rights is never in a child's best interest is actually supported by some literature. But just because it's supported by the literature that a child does best when they are raised by their biological parents doesn't mean that that parent should have endless opportunity to be reunified with their kid. The child should have permanency and predictability, and if the mother does well in 4 weeks or 6 weeks or 8 weeks and falls off the wagon in 2 months and we're back in court again and we have to petition again and be involved again, it does nothing to establish permanency for the child.
Surely those studies consider these variables we're talking about. Well, I mean, it's clearly not good for a child to be raised in a biological home where they're continually abused.
But how severe is the abuse?
Okay, pick one.
Okay.
It doesn't matter. I mean, it's severe enough at some point to be detrimental. They'd be better out of the house, out of the home than in it.
Well, what if the abuse is that the parents are homeless and that they've chosen a nomadic lifestyle and they simply don't believe in...
Yeah, I'm just saying that you can't make a blanket statement that a kid is always better off in a biological home.
I agree with you.
That's what I'm trying to get at.
I agree with you. You are right.
There are conditions under which that doesn't apply, and that's where I think we're trying to get to is where does that line, or not line, that big wide gray area that...
The gray area.
Yeah, that we're trying to assess.
And one of the Montana Supreme Court is really useful in their language because they won't use black line tests for things because they recognize the individuality of the circumstances and facts of each individual youth in need of care case. And so it's incredibly difficult to apply a bright line test to when is it in the child's best interest, and it is always fact specific. And so it really comes down to an issue of your discretion and your judgment and your opinion. And
The judges, really.
it comes down to the judges, yes, but I'm trying to answer your question about you want to know when you should be saying, Judge, this is what we think is best, or I think is best. That's your decision, and you're never wrong. It's wonderful You are never wrong. As long as you are honest, you can't be wrong.
We're never wrong because it's an opinion.
Yes, it's an informed opinion. I mean, it's an informed opinion.
Right.
Yeah. As long as it's honest, every answer is an A+ answer. It's wonderful going to court. Wait till the cross-examination comes later.
Doesn't it matter? Doesn't it? At the Supreme Court, don't they view it at its best interest of the child? I mean, that trumps
Parents' rights.
Correct. So you talked about before I got up here, you were talking about a little bit about the tension of the constitutional right to parent versus the child's best interests. And I recognize that tension is present and it exists, but as the department's attorney, I am always advocating for the law, which is much more explicit, that the child's rights are paramount to the parents, and that the child's rights actually trump the parent's right to parent, and that the child's best interests are the most important thing, and the child's constitutional right to grow up in a safe and healthy environment. And as the department's lawyer, that's how I go to court. Behind closed doors, when I'm talking with CFS, I generally am much more balanced and try to say, how can we, do something about this? But in court, when you hear me advocating on behalf of my client, that's what I pound on every single time. And when I'm writing my briefs to the court and I send them to you, you'll see that's what I'm hitting on too. And the Montana Supreme Court follows suit. And that's why, since the public defender system went statewide on July 1st, 2006, there have been 3 cases reversed on appeal, youth needed care cases, by the Montana Supreme Court. One was a judge applied the law slightly inaccurately in a termination of parental rights specific to how treatment plans go and the presumption of termination at 15 months, when a child's been out of the home 15 of the last 22 months. And the judge looked at the record, didn't have a new hearing, reapplied the exact same facts to the correct law, and still terminated parental rights, and the Montana Supreme Court affirmed. So that's not much of a reversal as far as I'm concerned. The other one, the lawyer did not respond to a brief, and because the lawyer failed to respond to a brief, it was ineffective assistance of counsel, and so that case was reversed because parents are entitled to counsel, and if you're entitled to counsel, you're entitled to effective counsel. And the last case was a case involving the Indian Child Welfare Act out of Yellowstone County this past year. I'm sorry, it was just the end of last year, Gesundheit. And in that case, the tribe was not the one that declined to accept jurisdiction. Instead, it was the Indian Child Welfare Act expert. And when a case involves an Indian child, you can either be tried in state district court or it can be transferred to the tribe if the tribe accepts jurisdiction. And because the court did not apply the correct criteria, that was reversed, and so that ICWA case was revisited. But in those 3 cases, the child's rights are paramount, and generally the Montana Supreme Court will give great deference to the district court judges who make the determination to terminate rights and affirm them to make it in the child's best interest. Yes?
I'm just curious, you keep saying that you guys are going for the rights of the child, and that is paramount to what you guys do. So when we come in as CASAs and we're stepping in for that child, also, in what aspects do you think your place has diverted from that main goal and CASA steps in? And do you ever disagree with what CASA says that is the best interest of the child?
Sure, yeah. I actually remember testified that she believed that termination of parental rights was not in the child's best interest. And my cross-examination of her focused on that. I thought she was saying that by proof beyond a reasonable doubt, the department had not shown that termination was in the child's best interest. But by a clear and convincing evidence standard, which was that the department's burden of proof is less than that, the department had met its burden and had shown that it was in the child's best interest. And she refused to agree with me. But the judge did agree with me. or with my client, not me personally. And yes, sometimes I do disagree with CASAs when in that instance.
Can we cite you when you did disagree with us that you said we're always right?
So we're always right.
It's on the
Disagree.
camera. You're on the.
Always right.
Just because you're right
You're right
Doesn't
about this. That's it.
doesn't mean I agree with it. So you can be right, and we can disagree without being disagreeable. So let's see. Oh, good. There is more about the law of what the ASFA tells us. Termination petition if a child's out of the home for 15 of the last 22 months. Permanency hearings have to be held every 12 months, and there have to be some specific findings in the court's orders, such as this is in the child's best interests, and that Child and Family Services has engaged in reasonable efforts or active efforts to reunify the family. So Montana has constitutionally protected rights, including fundamental rights, unless precluded by laws that enhance their protection. That's what the Constitution says. But interestingly enough, this top one that's cited here on this slide, I would never argue to a judge, because this one is actually from Title 40, and it's a different part of family law. And this is what happens in divorce cases and the standard that the judge is supposed to apply in divorce cases. And I don't rely on this law, though it's there, because it's not part of the youth in need of care statutes that I'm operating under, which is Title 41. But it does show that Montana does give good protections to children, just on the whole. Children are entitled to assert their constitutional rights. Provides for the protection of children whose health and welfare may be adversely affected and threatened by the conduct of those responsible for the children's care, and achieved in a family environment when possible. And the Montana Supreme Court has interpreted when possible means if it's not possible, you can terminate, and it's fine. So the guiding factor are the child's best interests. Paramount, they take precedence over parental rights. I'm telling you what the law says. This isn't my position. The law says it takes precedence over parental rights. Now, I know that that's what the law says, but I will tell you that your district court judges here do not approach it that way. From what I...
No. Finish your thought, and then I have a different thought.
My experience with our district court judges is they will place children on the same plane as their parents, and they will not elevate children's parental rights, because our district court judges here in Missoula County have such a strong view of the importance of the parental right to parent. The regional administrator for the Western region of Child and Family Services 4 years ago once told me that the burden of proof in Missoula County is higher than it is in the rest of the state of Montana.
Termination.
Just in general. In general, the burden of proof in Missoula County is higher than it is in the rest of the state. And this was somebody who oversaw courts in Lake County, Flathead County, Deer Lodge County, and they were impressed at the differences and how very similar facts would result in disproportionate outcomes. What was your thought?
Well, if you flip back a slide.
Sure.
Right? So basically, well, it's 2 slides. What we have is we have a constitution that guarantees children constitutional rights.
Yes.
Right? Okay, so right to bear arms, right to, seriously, right to.
Same as an adult.
Right to free speech, the whole that. But then the slide that we were just on talks about the parent, that we're supposed to look at the best interests of the child. So I guess what my question is how is that balanced in the law? Their constitutional right versus, I mean, is there a conflict between the best interest of the child and their constitutional rights? You see, I mean.
Yeah, no, I think I understand your question. Is there a conflict between the child's best interest and their constitutional right? So the exception in the Constitution says that Children have a constitutional right unless laws are made for their protection.
Okay.
So that's what the whole clause of the Constitution says. And I should probably improve the slide so that I have the whole language up there.
That's good. So what this is aimed at is, we're improving, we're doing something that's more protective now.
Correct. So like children are allowed to have...
Like you can't have a gun.
You can, as long as you have an adult,
Right.
and you have an adult with you when you go hunting. And I believe it's 10 to 12 you're allowed to do that,
Right.
but it's not until you're 12 that you can have your own. And that's made for the protection of the children, as opposed to the constitutional right of a well-regulated militia.
Right.
So,
So the best interest is codified in the law.
correct.
Yeah.
It's not, there's not really then a discussion to be had on whether we're supposed to be looking out the express wishes of the best interest.
Allow me to go there for you.
Oh,
I'm sorry, I just can't resist.
No, I think it's an important conversation to have. Do you want me to do it right now, or do you want me to
No.
keep going?
I'll hold that thought,
Okay.
if you're gonna get there.
Oh, I'm gonna get there. Don't you worry. Okay, so child abuse and neglect procedures. There is a right to due process contained in the United States and the Montana Constitution. Your right to due process is both a substantive and a procedural right. And to keep those rights present, we have very explicit procedures set forth. They are beautiful, they are simplistic, and they are rarely followed in Missoula County.
due process means the right to procedures,
Yeah.
court to be heard. Or,
And I want to be clear when I say that they are rarely followed, it is by agreement that they are not strictly followed. And it is done for a variety of reasons. And my personal view and my practical view as an attorney are inconsistent with each other. So I'll get into that for you now. So Child and Family Services receives a report of child abuse and neglect into the centralized intake in Helena. This begins a Child and Family Services social workers' insulation from liability against a lawsuit and begins their work as an agent of the state. The government then takes action, okay? So they investigate the report, or they say this is not important and we're not going to take care of it, or they say this is not a familial issue, this is an issue of non-family members, and they refer it to local law enforcement. In the event that there is a determination that there is child abuse and neglect occurring, the department will try to help the family voluntarily. This is called reasonable efforts to keep the family together. And it's one of the first questions we should all be asking ourselves when we get our case. What reasonable efforts did the state of Montana engage in to try to keep this family together prior to taking this child outside the care and custody of their parents? When those voluntary services agreements are unsuccessful, what do we do next? Well, generally what happens is the reason why they are unsuccessful is because the parent either refuses or is incapable of doing something that will remediate the issue that's led to state intervention, whatever that intervention is, however slight it may be. So what the state does is we file a petition with the court. We say, Judge, we are going to have an adverse impact on these parents' rights, and we want a court order saying that what we're doing is okay. And if the judge says it's not okay, then that's the end of the case, and you're never a part of it. But what happens is we file a petition. We ask for 3 things in, let's say, 95% of our petitions. EPS, ADJ, TLC. Welcome to alphabet soup.
ADJ.
Adjudication. EPS, Emergency Protective Services. This gives Child and Family Services the right to place a child outside the physical care and custody of their biological parents. And when you are, I will give you a bad analogy, but one that we can all understand. When you are arrested without a warrant for a criminal offense, the government then gives a judge, an impartial magistrate, an affidavit, a sworn statement, establishing why you were arrested without a warrant. And the judge within 48 hours says, it's okay that you arrested this person without a warrant, and signs off and creates a warrant justifying the arrest within 48 hours. And an impartial magistrate weighs in on the decisions of that law enforcement officer who conducted the arrest. when a child is placed outside the physical care and custody of their parents, the same procedure occurs. Child and Family Services brings an affidavit, a sworn statement, to my office. My office reviews it, and then we draft a petition for the court, and we ask the judge to sign an order granting emergency protective services. And that also is an order then called show cause. Show cause why the department's prayer for relief or petition should not be granted. The judge says no, then within 5 to 7 days, the child is returned to the biological parents. If the judge says yes, then within 20 days, we're going to have what's called a show cause hearing. After the show cause hearing, there are all sorts of things that can happen, but that's about the time where you as a CASA are going to come onto this case. The judge signs an order to show cause, granting the Department Emergency Protective Services, and hopefully that's when we bring you on, and that's when your investigation begins. Yes?
Okay, just to clarify that a little bit. So
Sure.
The petition you just talked about, the judge grants it within 20 days, you have to have the show cause hearing.
Correct.
And at the show cause hearing, you present more, it's more like a trial with evidence and witnesses and so forth to say, here's the real evidence that says this should be a long-term deal?
Depends what jurisdiction you're in. So let me tell you about how Missoula County does it, and then I'll tell you what other counties around the state do. When a judge grants emergency protective services, the judge has found probable cause. That's a legal term of art. It's a standard of proof. It's pretty low to find that the child may be a youth in need of care. And you go to the show cause hearing and you ask the parents, do you contest that there is probable cause? And the parents can say, look, it's not true that I was testing positive for methamphetamine, but it is true that I struck my child. And the judge can say, okay, I understand you want to contest the methamphetamine and drug, chemical dependency, but you don't want to contest the child abuse part. I find there's probable cause, we're moving on, and there's no hearing, and that's it. It's a show up, introduce yourselves to the judge and move on, and there's very little substance that occurs. Yes?
And when the parents don't show up, like today?
When the parents do not appear, it depends. So today there was a hearing that I had where the parents didn't appear because their lawyers told them not to come. And that's because we had an intervention conference set for this afternoon, and we went to an intervention conference and we sat down at a table just like this across from each other, and had a conversation about, look, this is what treatment looks like. This is what we're going to do to try to help reunify you and your kids. And the parent said, thank goodness you're here. I've been trying to get treatment since August. This is wonderful, and I'm so glad that you're going to be able to help me get through this. So we have agreed, so we're going to go back to court in 2 weeks. Parents are going to walk in, and the mother is going to say, you can adjudicate my child or youth in need of care. You can grant temporary legal custody to the state of Montana, and they continue to have the ability to place my child out of my physical care and custody. And Judge, I'm so glad to have this treatment plan that tells me exactly what I have to do to fix everything that got my kids into the system in the first place. And when I have made substantial completion of this plan, I look forward to having my kids back. And when my kids are back in my care, I'm going to continue working this, and the department's going to continue to help me through it. And when we dismiss this case, you're never going to see me again. And my kids will never be in the child welfare system again.
And in 2 weeks when they don't show up? I mean, if they don't show up, then not what? Then is it, do you petition for termination then? Or do you?
No,
How many options do they, I mean, how much?
So I'll give you, let me try a different case instead of using this one. Child's mother passed away of drug overdose when he was 2 years old. Child and Family Services went and investigated the biological father, no drug abuse history, protective, little eccentric, but okay. 12 months later, child abuse report comes in, Child and Family Services investigates, and the father is starting to show paranoid schizophrenic traits. And his sister describes him as turning into their father, who is institutionalized. And so Child and Family Services says your child is not safe in your care, and we are going to try to do something to help you. The father never appeared at the show cause hearing. So the department served him by publication, and we published in newspapers. And that we could reasonably calculate he would see. He's here in Missoula. Put it in the Missoulian Independent 3 weeks in a row. He never showed up, and the judge adjudicated his child youth in need of care. The department reached out to him through his sister and spent over 6 months trying to get in touch with him and trying to bring him into the fold of treatment. After almost 12 months, the department asked the judge to please terminate his parental rights. He was incarcerated on a DUI charge, and we gave him a copy of the termination petition and a summons to appear, which said your failure to appear may result in default. And we would enter a judgment defaulting your termination of parental rights. And he was released from bail on Monday, and at the termination on Tuesday, he did not appear. And so it was 12 months, and the judge terminated parental rights.
All through that process, though, there he was still represented.
That's correct. He was represented by counsel throughout, top to bottom. He never met with a lawyer. Lawyers went to his house and knocked on his front door. He was evicted from his apartment about 2 months ago. But when he was incarcerated in jail, the department contacted his attorney and said, please go visit him. And his attorney did not go visit him. And his attorney was unable to make contact with him, believing that he would be there on Monday, the day before the hearing, and instead he bailed out in the morning. So when they were there that night, they missed their opportunity to have a conversation. And that child has permanency. And that child's permanency is with his sister, the one who identified that he was starting to have these issues with his psychological stability. And his sister is going to be able to have some relationship between her brother and her adoptive son, what will be her adoptive son. And so that parent-child contact isn't severed forever. It may be severed legally by a judge, but that biology is always going to be there, and it's really in that child's best interest that that child is with family and will stay with family. And the hope is that over time, the father can get whatever treatment he needs and have involvement with that child's life. But I don't think anybody particularly wants him making decisions about that child going forward. And I think even opposing counsel might conclude that termination of parental rights truly was in the child's best interest. Although the attorney on the other side did a great job of advocating for their client and doing a vigorous cross-examination of the social worker about their efforts to get in touch with him, the father. And he was more than ably represented by counsel throughout the entire proceeding. And because he wasn't engaged in treatment, there was never a court-ordered treatment plan. There was no treatment plan to foster reunification because he wasn't engaged. And I believe that's referred to as apathy and indifference by the Montana Supreme Court. I note actually that lawyers will respond differently to different cases, and I'll start with myself as Exhibit A of how I respond to certain cases. And when if something goes wrong or sideways in a hearing in a case, I will immediately become on edge in that specific case in a way that it doesn't affect me in the other cases. And I try to let that case go to the way and move on to the next case where it can be the same lawyers on the other side, but we have a different relationship in that case. And for whatever reason, we're proceeding differently, and the hope is that it's going to be better than the last one. But I also note that is specific to social workers whom I work with, the ones who are bad at paperwork are always bad at paperwork. And the ones who are great in the field at doing social work are always great in the field at doing social work. And there needs to be some balance by Child and Family Services social workers between doing your paperwork and getting it done on time and being a social worker in the field, helping the family in the field and working to foster reunification. And you can't do one or the other well without, so well that the other one suffers. They're really co-occurring, as it were, that they need to do both well in order to be successful in their position as a social worker representing the state of Montana. That's what I believe, and that's what I counsel them, but they're their own state agency, and they can do whatever they want, and I have no control. And so if they decide that things should be done differently, I'm stuck. And that's what I get to go to court with. And I will do the best job I can of advocating for them, even when they have made their errors. Because who among us hasn't? Starting right here. I just don't want to see any of those errors have an adverse impact on a family, and particularly on the children. So ethics, clients are the number one concern. So would you want to talk about child's best interest versus and their voice? If I'm a lawyer, oh, this is great. You get up and go get food the moment I hit your topic. If you want to talk about being an attorney representing a child, the first thing that I have to do ethically is assess that my client is of what's called, under the law, diminished capacity. They're under 18 years old. They cannot enter into a contract. They are not a grown-up. Some of them are not even verbal. And no child wants to go home to an abusive situation. But if that child doesn't know it's abusive, how are they possibly going to express something other than, I want to go home to my mother or my father, or both?
Do you see enough history now, when it said that instance you just cited, do you see enough of those where you start to get a sense, as you watch them, what happens after they're reunified in maybe a way that you didn't agree with, that validates or maybe invalidates your...
Oh, yeah, you know, one case I had, I couldn't believe the judge did this. A parent had assaulted their child in such a way that I was firmly of the opinion that the right thing to do was to terminate parental rights and make no efforts to reunify. And the parent pled guilty to the assault and was sentenced to 20 years to the state mental hospital, all of it suspended, under supervision. And the judge said, no, you have to engage in reasonable efforts to foster reunification, give that parent a treatment plan, the child is a youth in need of care. I was aghast, and I was flat wrong. That parent did everything under the sun. That parent did so much more. The department asked to bring the father on as failure to protect and not being in a protective capacity, and the judge said no and threw him out of the case, and he had no treatment plan. The child was reunified with the mother. That parent's probation officer, it must be 2 years after the case was dismissed. The parent and the child worked together with the department for over a year. The department said the reasons for intervention have been resolved. They dismissed the case. The probation officer called me almost 2 years after that and let me know that the father, who had not been part of the case, had actually become an abusive spouse and a freeloader on the mother. And the mother said that your conduct is having a negative impact on our child, and your conduct is having a negative impact on my sobriety and my continued sobriety. And she tossed him out. She filed an order of protection against him into justice court, and she got a parenting plan giving her exclusive custody of the child. And he has to pay child support. I mean, talk about me being wrong or my client being wrong. The department, that parent did everything to show that that judge was absolutely right, because that parent is more than protective and is at least as good a parent, if not better, than all of us sitting at this table. So there's my favorite example of how wrong I have been and can be. To the role of child protection specialist. So in the state of Montana, there is a thing called a license to be a social worker. To distinguish between licensed social workers and the people who work at Child and Family Services, people who work at Child and Family Services are unlicensed, so they are called Child Protection Specialists, CPS. I'm a lawyer. I follow the law. The law says social worker, and I refer to them as social workers all the time because that's what the law says, and my client refers to themselves as Child Protection Specialists. You're going to see both, and you will refer to them as you see fit, which is probably on their first name basis.
So where are the licensed social workers? Where do they work?
Licensed social workers end up being therapists, and yes, private, but generally not working for the state of Montana. So child protection specialists, their role is to investigate allegations of abuse and neglect. They write affidavits in support of their positions, and they work with families, parents and the children to address abuse or neglect issues, and they provide services to promote reunification or the permanency plan. So a lot of times what Child and Family Services does is they make referrals to other providers throughout the community. They don't provide the individual counseling to the parent or the child. They don't provide the family therapy. They don't do the chemical dependency evaluation. They don't do the psychological evaluation. They don't do the neuropsychological evaluation. They don't do a lot of the things. They don't.
They pay for that though, or is
Correct.
that what- okay.
We pay for it. It's our tax dollars at work. We- Correct. Yes. If it's in the treatment plan, the department pays for it. They facilitate visitation, and they end up doing it with the with third parties a lot of times. And one of the things I've been hearing from one judge has been very astute. As the department's resources are taxed more and more, and as social workers are stretched thinner and thinner, and their caseload grows more and more, the judge has said the department needs to look at how they are going to provide visitation between parents and children that are separated that is outside the box of what they usually do. Are you going to have a foster parent do it and supervise? Are you going to have a grandparent come in and supervise? What are you going to do to try to close the gap? I think as a matter of course, we should refer to it as parenting time instead of calling it visitation. And if we can change that in our vocabulary, I think that we can have a positive impact on the families. There's some little things like that that we as a community can do better for our cases. But at the same time, some of the parenting time isn't necessarily the problem. The problem isn't necessarily the separation between the child and the parent. Sometimes more parenting time isn't beneficial for the family. Sometimes it's actually harmful to the child. What's important is the quality, not the quantity. And it's different from case to case. And so you're going to have to make that determination, and frequently you will have to weigh in on it. In fact, I do recall one case where a CASA actually was the supervisor for the visitation. And the department was unhappy about it.
And so was the CASA office.
Okay?
That's,
Not
we
your
don't want that to happen. That's not part of your role.
Observe but not supervise.
Exactly. So cool.
No, that's important for me to know. I wasn't aware that the CASA office was would have preferred a different outcome. But I do think that it's important for all of us to get creative about what's in the kid's best interests and why. Perfect example was I had a judge who ordered a child to be present at the mother's urinalysis test. And if she would provide her urine into a cup, which she hadn't done in 6 weeks prior because she missed every single test, then she was to have a visit with her child. And I can only imagine the harm to that child when the mother doesn't show up, or does show up and refuses to provide that urinalysis sample because of what it may show, and would rather not provide the sample than have the visit with her child. I can only imagine the harm to that child. And that's one case where I don't agree with the court, but I don't wear the robe. And the judge was the one who was managing that visitation schedule for that family. That is an incredibly important part to make because there's a shortage of foster parents. And when you have one that's a good one, you want them to stay that way. You want them to stay as a foster parent, and you don't want a judge's order overburdening that foster parent. I think that's fantastic. And if you as the CASA can step up and be a voice for that placement, I think that you do your client, or not your client, excuse me, you do the child and the foster parent an incredible service. There are some outcome meetings that foster parents are not included on. So let's talk briefly about confidentiality. Title 41, Chapter 3, 205. Okay? Montana Code laws say that these cases are sealed proceedings, with the exception of the 26 enumerated exceptions, A through Z. Now, among those exceptions does not include foster families. They have the right to appear and be present in court, but they don't have the right to participate in the proceedings. This is done for two things, two reasons. First, the child is done nothing to come into foster care. So the child has an absolute right of confidentiality. So in the event that that child and the foster parent are not, do not stay together and the child is returned to their parents, that foster parent doesn't get to keep all this information and learn all this stuff about the child, or the family for that matter, and the parents, and have that information going forward. Not until the adoption is completed, as it were, does the foster family entitled to that information. So that's one reason that there's an insulation. The other thing is, you don't want foster parents to be any more invested than they already are. They are committed to being placements for these children, but we don't want them to assume an adversarial role with the biological parents whom they are supposed to, on some level, be bridging a gap in parenting. They're supposed to be helping these people, and they're not supposed to have the vested interest of, I want these parents' rights terminated so I can adopt this child I've been caring for insert length of time here. There actually is a case that I just read that came out of Colorado where the foster parents were actually granted a right to intervene as a party. And they became a party to the case. They got a lawyer who gave opening and closing statements, cross-examined witnesses, and they got on the stand and they provided additional testimony and facts that only they knew that the court would not have received otherwise had they not been able to participate. Now, I don't agree that the court wouldn't have gotten it otherwise. There's nothing to prevent the department from asking the foster parents to testify. But they got to advocate for what they wanted, which was termination of parental rights and adoption of the child that they've been caring for. I want to say it was over a year. I know it was over a year, but I don't know exactly how long. And the Colorado Supreme Court affirmed their right of intervention as a party to the action. And I think we can sit around and have a debate for a couple of hours about whether or not foster parents should be able to assume that that right to intervene in the case and say, this is what we want for this child, and instead leaving them on the outside. And the way Montana does it right now is they are on the outside looking in, and they are insulated from a lot of information in the case. I've given you the two reasons that I see, although I have to say I've been impressed with some cases where I never saw reunification as possible and it occurred, and I've seen other cases where I was certain reunification was going to happen, so certain that CFS actually didn't do concurrent planning, and it wound up with a termination of parental rights, and the department was left scampering for a placement for a child that wasn't an emergency shelter. And there's a benefit to not telling foster parents a prediction about what the outcome is, because we plain and simply don't know. As hard as we try to be correct about it, we just don't know what the answer is going to be. The parents involved in these cases surprise us at every turn. Court hearing guidelines. The show cause hearing happens within 20 days of filing. Then once that show cause hearing happens, so today, the one that you were in for was a show cause hearing, and we set it over for 2 weeks. So we sure didn't have a show cause hearing today, I'll tell you what. But the benefit of it is the next thing on here is an adjudication hearing within 90 days. We're not going to have an adjudication hearing because in 2 weeks when we go back to court, this parent has made an informed decision with the advice of counsel that the correct thing to do is to allow the court to grant the relief requested. They're going to adjudicate the child to youth in need of care. That's a real benefit to everybody. When you don't have a contested hearing at the beginning of the case, people are not at each other's throats. They are not mad about you bringing up their upbringing and every bad decision they ever made from the time that they were 2 until the present. You have a working relationship that you are beginning to foster. It is a very positive thing to get stipulations. Just because it's a positive thing doesn't mean that we shouldn't have contested hearings sometimes. There's a real tension because sometimes the right thing to do is to give the judge the facts and make the judge rule. sometimes the right thing to do is to have an adversarial hearing. We are an adversarial system. For better or for worse, that's what we have. And sometimes it's a positive thing to do that. The thing that bothers me that I see sometimes is parents will see their lawyers fighting tooth and nail and believe that their lawyers are hired bulldog, which they are. Lawyers do a good job in the courtroom in Missoula County. There's no shortage of good lawyers here. But parents sometimes get the wrong idea and think that they can get away with things because their lawyer is such a good advocate. And they think that they don't have to do the work that's necessary to foster reunification because their lawyer is going to get them off. And there's nothing beneficial about parents having that reaction. So, going back to stipulations then, after there's an adjudication hearing, you will see nothing take longer than a disposition. There are two statutes in the law. One is disposition statute and the other one is the treatment plan statute. There is disagreement in Missoula County among the attorneys about how dispositions are to go. My legal position to the department as their advocate and my legal position as an attorney who is just a big nerd and likes reading law and cases is that the disposition is the time that the court orders a treatment plan for the parents. And the treatment plan for the parents is what fosters reunification. And to tell the court more specifically what the treatment plan looks like, there's actually a separate statute to say this is what the treatment plan should look like. As opposed to some of my colleagues who believe that the disposition hearing is actually the time when you have a hearing to decide whether or not the department should have temporary legal custody. And a treatment plan hearing is an entirely separate procedural matter that has nothing to do with disposition. All that said, let me put it really in context of this case this war story I'm telling you about, my case today. The mother is doing everything on this treatment plan that she just got last night at 4:45. She knows what she's supposed to be doing and she's been doing it. And she is on the road to recovery. And everybody in this case is really overly optimistic that she's going to be successful and we're going to have a successful reunification here. And the lawyer for the father, though they have never seen the treatment plan, was more than happy to not have to be present today in court and set things over because the father has fallen out of contact with the attorney. And so he can't engage in treatment if he's not engaged with his attorney and they're not having a communication. So, no harm, no foul? I don't know. But I know that I, as a lawyer, trying to be as strict as possible with parents when I advocate on behalf of my client, I expect the same thing from my client. And we don't always see it. You as CASAs can step in on some level and you can chase up the social worker and say, look, we're supposed to have a treatment plan here. Where is this? And you as CASAs can chase up the social workers and say, look, we're at 11 months. I want a written report from you about what the permanency plan is going to be for this kid. Because I'm writing my report, because you're going to write your own report at 12 months and say this should be the permanency plan, Your Honor. And you're going to want to see what the social worker has to think about it. Oh, I'll get to it, I'll get to it, I'll get to it. I have 7 different cases that are on my desk, and they're all priority ahead of getting that permanency plan done in the next 2 weeks. But I'll get to it in 2 weeks and get back to you. Well, you get to chase them up.
What authority do we have to nudge?
What authority do you want? You're the CASA.
Excellent. We get an order from the
I got
judge?
20 minutes.
You got about 10
I got.
max.
Oh, really?
Yeah. Matt, at the beginning, he was going 2.5. How am I ever going to fill up 2.5? And here you are.
Let that be a lesson to me to open my big mouth. So let's blaze through some stuff.
Yeah. Does that have writing on it?
So I'm going to email a copy of this PowerPoint to Dennis, and he's going to pass it around to all of you. And this is a flow chart of your timelines. Take fewer notes. So hearing descriptions. I've told you about what a show cause hearing is. Adjudication hearing. The question is whether or not there's a preponderance of the evidence, tipping of the scales, about whether or not there should be governmental intrusion into the family home. That's not what this says, but that's what I think it is. And why is the department involved? That's what the adjudication hearing is. It's hearing on the merits of the position, of the petition. After that is the disposition hearing. We've talked about that. My position is that it's a place to have treatment plans ordered.
They also talk about placement there, do they not?
They can. The judge has the right to talk about placement at that time. The parties have the ability to address it, and any party to the action can object to placement at any time and bring it up as an issue. But generally, we try to resolve that behind closed doors, and when we can't resolve it behind closed doors, then we bring it to the judge. You will, yes?
Essentially, are you trying to bring done deals to the judge?
Oh God, yes. Because if you bring a done deal to the judge, then there's no avenue for appeal. You don't make protracted litigation. The judge has to make fewer decisions. The parties are working together cooperatively, which is what you want if you can do it. And it makes the whole case go faster. You spend less time in court arguing about things, you spend more time doing social work. These cases are about social work and trying to help reunify families and keeping families strong and safe. This is not about law if you can avoid it. So let's see, after 6 months, temporary legal custody can be given to the department for up to 6 months. In between, judges will have status conferences periodically. At the end of temporary legal custody, the Child and Family Services has a legal obligation to ask for something else. Please dismiss the case, please extend temporary legal custody, or please grant something else. Terminate parental rights. We haven't seen or heard from either parent in 6 months. Give the child permanency and let them be in their adoptive placement. Or we've reunified this family and we want to dismiss this case and there's no issues here anymore. Termination hearing is when parental rights are by law severed. And just because the parental rights are severed by law, we all have to remember that that relationship between that child and that parent is biological and it will never be severed. It is simply a legal procedure that is in the interest of the best child. Permanency plan hearings have to be held every 12 months. So once every 12 months, judges have to review cases. Judges are supposed to conduct an age-appropriate consultation with the child. How does a judge do that? Well, in Missoula County, there's a great reliance on CASAs to go to the court and say, look, it's not in the 3-year-old's best interest to have him here in court interrupting breakfast and his nap schedule so that he can be here to have a conversation with you, who's only so verbal. So instead, judge, let me tell you what I know. And you tell the judge about your interactions with the child and the foster family and the biological parents and how well things are going. Or maybe it is in the kid's best interest to come to court, or you do it in chambers, or the kid's 16 and wants their voice heard, personally one-on-one with the judge. You as a CASA can weigh in on that. This is a chart which is marginally accurate about different burdens of proof. Proof beyond a reasonable doubt, beyond all doubt is at the top, the bottom is probable cause. All right, so here's a little thing on testifying, okay? Not a big deal. We can all do this, we can get through this. You get to do written reports. That's what the top says. You have an obligation to do a written report. The bottom says this: information contained in a report filed by the GAL or testimony regarding a report filed by the GAL is not hearsay when it is used to form the basis of the GAL's opinion as to the best interest of the child. Now, like it or not, in Missoula County, CASAs fulfill the role of the guardian ad litem. So this applies to you. Now, as a prosecutor, I would love to see all sorts of delicious hearsay in all of your reports so that I can subversively slide in all these statements from all these people that I don't have to testify and aren't subject to cross-examination so that you can testify about what they said to you. That would be a great trick for any lawyer and every lawyer to pull. And so as long as you're only packing it for my client, have at it. No, I think that what you should do is you should base your opinion on fact. You should base your opinion on what people have said to you. You should base your opinion on, this is the opinion of these other learned people, which leads me to conclude. include that stuff in your report, because then you can talk about it. If you include the basis of your position in your report, nobody gets to complain about you testifying about your position.
So not only are we fulfilled really the legal equivalent of an expert witness on behalf of that child, we can bring in hearsay, which would otherwise be considered hearsay, in support of our opinion.
So an expert has the right to rely upon hearsay if it's reasonably relied upon in their profession. And so if you want to say, so I think there's nothing wrong with a CASA saying, the parent told me X and I don't believe them because of these other instances. I think you can do the same thing about the therapist and say, the therapist told me this and I don't believe them because they've said this before. And this therapist is an objective, this therapist is an advocate. And some are. And that's their role. But I think that you have the ability then to say, I also spoke with this objective person, this person whom I believe is objective, and they said the following things. And based on these competing points of view, I've made the determination. I don't think of you as much as an expert as a judge, but you get to spell it out. And I think it's important to spell it out in your reports.
Nobody else in the process has that latitude. Even a physician has to base, he can't base his testimony on hearsay, or he has to base it on medical facts.
An expert witness has the right to rely upon hearsay.
Any expert.
Any expert.
okay.
Anyone who is recognized as an expert.
Given their opinion, which is hearsay.
But it's not hearsay, it's
So,
based on
well,
hearsay.
but if the doctor's called in as a treating physician,
Yeah.
then it's all going to be based on fact because they treated them.
That's what I mean.
If they're called in, but if they're called in as
As an
an
opinion witness,
expert,
okay,
so you got
yeah.
it? Okay.
Okay. It's still pretty significant.
Yes, it is.
Yeah.
Wow.
And so we're clear. I'm being completely facetious when I say you should pack it for my client. I think you should. I actually think that you as a CASA have an incredible power and ability to be able to give the judge a really good position. And I told you about one case where I was incredibly wrong about the termination of parental rights. And in that case, the CASA did an outstanding job of delineating the tension in the case to the judge about the child's relationship with the mother and not demonizing the mother as the child grew up, and the mother's conduct being so horrendous that there was a real push to conclude her involvement in the child's life going forward. And the judge said to the CASA, "You hit the nail right on the head." He was absolutely blown away, and I think it was also persuasive to him because it gave him direction about how to rule in the case, which was, I'm not going to terminate parental rights today. I'm going to make a determination about whether or not we should, I'm going to order a treatment plan, and then we can decide based on trying to reunify.
Telling me about where they had all the witnesses and whatnot, all that were lined up, and the judge goes, I read the report from the CASA, and then that was it. You don't need the witnesses, don't need anything else. We're going to do what the CASA said.
Yes, that's
that
correct.
was the case. Wow.
Okay, so testifying, you have the right to know, understand, don't reach, be straight in your answers. Every answer that's honest is an A+ answer. You can always understand the question, ask for clarification if necessary. You don't need to be confused. Lawyers will put words in your mouth. We're very talented at it. And it's by accident. It's not by training. You make sure that you tell your story. You have the right to have your memory refreshed. If you want to look at something or review a document, or someone's asking you about a statement you made, you say, "Gay, can I see what you're talking about?" Go for it. Don't ever be afraid to ask a question to be repeated or rephrased if you don't understand something. Otherwise, you're going to answer something you didn't know you were answering. You heard Dennis talk about being brief and not rambling on. It's important to be consistent, logical, and sequential. I believe that it lends to your credibility when you are talk that way. The real thing for me is that once upon a time, I would speak to lawyers in a way that was not sequential, and they would get lost and irritated. And I was unpersuasive as a consequence. You, as CASAs, are testifying before a judge who is a lawyer in a robe. And to be persuasive to that lawyer, you want to talk like this so that they don't get lost or irritated. Direct examination, that's when someone's going to call you to the stand. They're going to ask you open-ended questions. You get to tell your story. Let's see. I think the last one here I think is really what's important is you can have a conversation with the person because it's more comfortable for you, but there's no jury. The fact finder is the judge. You can have a conversation with the judge, and you've done it before, and you will have done it consistently. So I think that there's a real benefit to turning to face the judge when you do it. When the cross-examine, I'm sorry, yes?
Well, just kind of go, so narrative answers are prohibited?
Yes. So a narrative is I tell a story, literally, like, yeah, yes.
Okay. But
Like, tell us what happened.
Yeah.
And then you just go off for 20 minutes.
That almost, okay. Yeah, that almost should be said, questions shouldn't be open-ended, but you're saying they are.
They are open-ended. Who, what, when, where, why, how.
That's not open-ended, that's concise.
No.
What's open-ended?
Well, when you see cross-examinations, it's like,
Yes or no?
Yeah.
So a cross-examination question is one that's leading. It suggests the answer to you. Wouldn't you agree with me that methamphetamine isn't that horrific?
No.
Oh. You want to play? No. That's a closed leading question. How addictive is methamphetamine? Now it's open-ended. Well, methamphetamine is so addictive that, in fact, Child and Family Services routinely monitors cases with methamphetamine addiction at issue for 18 months and longer. So that's one way of going through it. Cross-examination is the other side's best opportunity to put words in your mouth. And they will try to get you to agree with their version of events. And that's exactly what I tried to do when we didn't agree. I tried to get her to articulate that she was holding the department to proof beyond a reasonable doubt, and that our burden of proof was only clear and convincing evidence. And she was great because she stuck to her version and she wouldn't agree with me, and that's fine. I made my point to the judge, but she was very clear that she believed that the best interest of the child was served by giving the parent another chance. And I don't think the judge abused her discretion when she disagreed. I think she followed the law, which is fine. It's a legitimate part of the process, and it's not personal. When your cross-examining lawyer gets personal, don't answer the question. Oh, you got kids of your own? Personal. Well, would you do that for your own kids? So let me get this straight. Do you do a criminal background check on every single babysitter that's ever watched your children?
What do we say?
You say nothing. I get to stand up and object and say personal reference. Or you can say, or if in the event that there isn't someone there to protect you and to stand up and object on your behalf, then you get to say, my personal life has nothing to do with this. This is about the facts of this case. And let me tell you about this family. So, because you're not represented by anybody, all the lawyers were glad to talk to you and tell you whatever you want to know. And our doors are always open. I'll visit with you anytime you like. And
If I'm gonna testify something, I could call you and say, look,
sure.
what's gonna go on here? What are the issues, what are the legal issues that I need to be aware of?
Yep.
Okay.
The other person you can contact is the youth's attorney. I've taken to asking youth's lawyers to put the CASAs on the stand so that they will please advocate for something and make it clear to the Montana Supreme Court that they are providing effective assistance of counsel to the child. So that's something that I've suggested in my cases. But I actually recall one case where I didn't particularly want the CASA to testify. The CASA filed a report, and the Montana Supreme Court says you can't rely on a report by itself. It has to be subject to cross-examination. So we said, Judge, toss the report, and she said no. So we said, put the CASA on the stand so we can cross-examine the CASA. And it worked out to my client's benefit. It takes a lot for CFS to intervene. There was one statistic one year where fewer than 6% of all cases called into centralized intake were filed as legal cases in the state of Montana.
How many?
Fewer than 6% of all phone calls, and that was in 2008. So it's been a while. I have 2 slides left, Dennis. This is some statistics on child abuse in Montana from 2010, and I'm going to skip over it because you're going to read it later. Children have the right to live their life free from abuse, and adults have the obligation to ensure that happens.
Oh, now there's a heartstring slide.
In these cases, every family is better out the back end. Either the family is better because they are successfully reunified, and then everybody wins. When parental rights are terminated, the only person who wins is the child. My client, the department, never wins in these cases. The government never prevails. A judge can rule in a party's favor, one way or another, but the only winners in these cases need to be the children. I hope that as you go forward as advocating for the best interests of these kids, you recognize that these children are the absolutely most vulnerable children in the state of Montana. These kids don't stand a chance. There are a few exceptions where you're going to be amazed that their parents have private counsel. But by and large, these children are the ones who are from broken homes and wind up in the pre-sentence investigation reports at 18 and 19 with their second and third felony charge. This is how we break the cycle of violence and keep these children out of the criminal justice system. This is how we keep them from becoming pregnant at 16 and 18 and never completing school. This is how we rise up our entire community by making each child in these cases better. And you're their voice. Any questions?
Thank you very much.
Thank you.